All right, are you going to join us at the... All right, we're back on the record. The appearances remain the same. There's a question that the jury has. Could we see the reports from the doctors that were submitted as evidence?
The state's position would be no. There's information in there that was not testified to. There's factual information in there, frankly, about the defendant that's negative to the defendant in some respects as well. There's prior allegations. There's information about his pending cases. I think there's just a litany of reasons why those don't go back to the jury. They're only relevant as they relate to the doctor's opinion. So I'm concerned that admitting those will allow this jury to consider those doctors' opinions as opposed to Dr. Robbins' opinion.
Well, these are competency evaluations.
Correct.
All right, Mr. Cotton?
We'd ask they go back.
Anything you want to stand on to support that request?
The jury's asking for them, and I think that it provides a thorough analysis of the mental health situation that Mr. Cayer has dealt with. And it sounds like they're asking for all the reports, which would also include Dr. Robbins' report.
Do you have any objection to Dr. Robbins' report going back?
Through it, I want to be sure that there isn't any information in there that is just patently inadmissible.
Well, that's my concern. There's so much that would have to be redacted from some of these other reports that I don't see sending back. And I don't think they bear relevance on the ultimate issue when these are competency evaluations. The relevant information was already testified to by Dr. Robbins thoroughly with regard to why he thought it was important to consider those competency evaluations. But they include much information that just wouldn't be appropriate to go back to the jury, and I don't know that we could possibly redact all of that in all of these exhibits. But I think it's worth looking specifically at Dr. Robbins' report, which was Exhibit 21. Do you want a copy of that, Mr. Cotton?
Sure.
The other issue the state has is, did they request Dr. Robbins' report, or did they request the other doctor's reports? So if they haven't requested it, we shouldn't send it back.
This is all doctor reports.
Could we, well, that's not what it says. I'll read you what it says so we have it word for word. Could we see the reports from the doctors that were submitted as evidence?
Yes. Okay, exactly. All the doctors.
Well, it doesn't say all the doctors. It says from the doctors. So
Okay.
I'm just clarifying for the state to answer their question precisely with the words that the jury used.
Okay. The doctors.
So I interpreted that as to include Dr. Robbins' report, although they did not specifically say that. And one would think if they wanted his report, they would have specifically said that. So I suppose you could interpret that either way.
I don't have a strong objection to them seeing just Dr. Robbins' report. I would strongly oppose them seeing the remainder of the reports.
Do you believe there's anything that needs to be redacted out of Dr. Robbins' report?
I don't think Dr. Robbins' report should be redacted if it goes back.
Okay. Anything you wanted to say about Dr. Robbins' report, Mr. Cotton?
We want the whole thing to go back.
The whole report of Dr. Robbins?
The entire report.
Yeah, I don't see any issue with that. So What would you like me to say to them in providing them Dr. Robbins' report and not providing them the other report?
Just say that the court is able to provide you the report of Dr. Robbins, but the court is not able to provide you the remaining report, or the reports of the remaining doctors.
Your Honor, I think that we should send this one report back. I don't think that we need to even give any explanation or answer to the question. And then if they want the other documents, they'll come back and say, what about the other ones?
Well, I just heard your co-counsel argue that it was clear they were asking for all the reports, so I think I should address that.
I think that wastes all of our time as well. If they've asked for all the reports, they don't want to send one back and come back here in 5 minutes when they say, why did you just give us one?
It's clear they want all of them. I mean, it's true they didn't put the word all in there, but it's very clear when they say the doctors, plural, they're referring to the doctors' reports. So I don't think we instruct them at all. I think we just give them Dr. Robbins' report and leave it at that.
No, I'm not going to just send them one report and not respond to their request. I always respond to jury's requests with some kind of information, even if it's just something like rely on your collective memory, whatever the question might be. I think that Mr. Lassay's requested language seems appropriate, and I will tell them that the court is able to provide them with Dr. Robbins' report, which is attached, but is unable to provide the other reports. Any objection to that, Mr. Cotton?
Just what we previously said, but that's otherwise no.
Thank you. All right, I'll provide them with that response, and the report will be in recess. Thank you. All right, I'll call State of Wisconsin versus Jacob Cayer, 2016 CF 902. The appearances are the same as earlier today. I'm told that the jury has reached a verdict. Please stand for the jury. No, I didn't. You did. I can see that. Okay. Please be seated. The jury has returned to the courtroom. Ladies and gentlemen of the jury, have you reached a verdict? Would you please hand the verdict to the bailiff? The verdict appears to be in proper form, and I will read the verdict at this time. State of Wisconsin versus Jacob Cayer. We, the jury, as and for a verdict, find as follows. Question number 1. At the time the crimes were committed, did Jacob Cayer have a mental disease or defect? Answer, yes. Question number 2. As a result of the mental disease or defect, did Jacob Cayer lack substantial capacity either to appreciate the wrongfulness of his conduct or to conform his conduct to the requirements of the law? Answer, yes. Dated at Green Bay, Wisconsin, this 13th day of August 2020, signed by the foreperson, 2 dissenting jurors, both with regard to question number 2. Before I accept the verdict, I will ask the jury if the verdict is your verdict and ask the jurors to raise their hands if their answer is yes. Ladies and gentlemen of the jury, is this your verdict? It appears everyone has raised their hands. Do the attorneys want the jurors polled individually?
No.
All right, thank you. Ladies and gentlemen, your service in this case is completed. Many jurors ask if they are allowed to discuss the case with others after receipt of the verdict. Because your role in this case is over, you are not prohibited from discussing the case with anyone. However, you should know that you do not have to discuss the case with anyone or answer any questions about it from anyone other than the court. This includes the parties, lawyers, media, or anyone else. If you do decide to discuss this case with anyone, I would suggest that you treat any discussion with a degree of solemnity such that whatever you do say, you would be willing to say in the presence of your fellow jurors or under oath here in open court in the presence of the parties. It is in the public interest that there be the utmost freedom of debate in the jury room and that jurors be permitted to express their views without fear of incurring the anger of any litigants or criticism of any person. Please respect the privacy of the views of your fellow jurors. Finally, should any of you have questions for the court before leaving today, please let the bailiff know before you leave. And I want you to know you may confer with me at any time before answering any questions asked by anyone. I do want to thank you, ladies and gentlemen, for your service in this case. I know it's been a long week. We started back on Friday, but I would ask if you would wait in the hall a moment. I would like to come out and speak with you before you leave. Thank you very much. Please stand for the jury. Please be seated. I'm going to take a moment and I'll be back after I address the jury. Please be seated. We're back on the record. Any motions?
I would move for a judgment notwithstanding the verdict.
Did you want to be heard on that?
No.
The issue with granting a judgment notwithstanding the verdict, in my mind, I would have to find that there's no way the jury could have relied on the evidence to come to the determination that they came to. And I think given the testimony that's been presented, they certainly could have relied on that to make their decision. So I'm not going to grant that motion. And instead, I'm going to grant the request of the defense. Is there any issue about your client and his request to participate?
Yes, he wants to be here for his disposition hearing.
I don't know what that means, because right now I plan to enter an order. I don't plan to have a disposition hearing. I don't plan to order, I don't need a dispositional report, and I don't think I'm required to get one.
My experience has been that courts are always provided with that, but certainly we'll leave it up to Your Honor what Your Honor intends to do.
Well, I think to order a predispositional report, my recollection is, and I'll look at the forms again, I have to find that I lack sufficient information to determine whether the commitment should be for institutional care or for conditional release. And I certainly don't lack sufficient information to make that decision. There's nothing that would potentially even possibly support him being on conditional release. I mean, there's just not even an option for that to be considered.
I don't know that we'd even ask for that, but you do have to make a decision about the length of the order, which I suppose is, one might argue mandatory life, but others might argue that there's the option to do a 20-year order given the eligibility that exists for homicide parole eligibility at 20 years. So I just haven't examined that further, frankly. So whatever the court wants to do is certainly fine with the defense, but we're requesting a disposition hearing so Mr. Cayer can be present for that.
We can put him on Zoom right now. I'm prepared to go forward now. I don't see any need to have a different hearing. I have to enter an order committing him and deciding placement, and I'm prepared to do that. Is the state requesting to go forward?
Yes, Your Honor.
All right.
Okay.
And he wants to participate in that? That wasn't the message that we got. The message that was forwarded was that he wanted to participate in sentencing, so I don't know what that means.
Right, because this wouldn't be a sentencing hearing given that he's not guilty.
Well, he was guilty. He was not responsible.
Not responsible. So since they made that finding, I think he didn't indicate he wants to be present for that not responsible hearing, or whatever you want to call that.
Do you want to err on the side of caution and get him on the phone or at a hearing?
I think so.
I think what he was communicating was if there was a sentencing hearing, he wanted to be here, but I don't get the sense that there's been any desire to participate in an NGI phase. So I don't think we need to have him here if the court's proceeding.
And Mr. Eichhoff, did you have a conversation with your client tonight after he made that request of the court? The message came in to the clerk indicating that he wanted to participate in sentencing.
No, Your Honor. Attorney Condon and I had a conversation with the clerk. We decided, based on the nature of his request, that we didn't need to have any further conversation since we wouldn't be proceeding to sentencing tonight.
Do you feel comfortable that he knows the difference?
It would appear so, yes.
I would agree with that, Your Honor.
Okay.
Your Honor, I guess from the state's perspective, I disagree with Attorney Cotton's position that the court has any discretion, frankly. I believe the statute's clear. Lifetime commitment is what is required on counts 1 and 2. Obviously, there are additional counts here, but I think a lifetime commitment is required, and it says subject to sub 5, which is the conditional release provision. So I'd be comfortable proceeding, just given the fact that regardless of what he says, the outcome will be the same.
Probably true.
One of the things under the order of commitment, it says that the court has informed the defendant of the requirements and penalties under certain sections relating to possession of a firearm, possession of a body armor, and I don't know how to accomplish that when he's not present.
That's true.
Okay, get them on, then that's fine.
Do you think phone is sufficient, or do you want them by video?
I think phone will actually be easier on her since he wouldn't be able to see us, he'll only be able to see you, so that way he's only hearing all of us as opposed to only seeing half of us.
Okay. What is your interpretation of the maximum term of imprisonment for the crimes? Because obviously the maximum for count 1 is life, the maximum for count 2 is life, the maximum for count 3 I believe is 60, count 4 12 and a half, count 5 6, count 6 6. That's 84 and a half I believe, plus 2 life. So I'm not sure what I'm supposed to do with that calculation.
I think the bottom line is it's a lifetime commitment.
Anything that you wanted to add to that?
No.
I guess potentially, Your Honor, the other issue would be the medication order.
I don't think I have a request before me for a medication order other than maybe the state indicating that it could be necessary. I think I would need a request from the facility indicating they were in need of a medication order. At least that would be my thought process at this point.